Welcome to the November 25th meeting of the Law Committee. Hope your Thanksgiving plans are coming along all right. Have anyone had a chance to review the minutes from last meeting?
Can I make a motion?
Yes.
A second.
Just a moment. There was a...
There was a proposed, I provided a proposed modification from Mr. Bergdorf, a very minor modification.
It basically is just adding that I did request an opinion from the county attorney on the burn ban legislation.
Yeah, we just need to consider the motion to approve the minutes. It's the first
I believe, well, there's also a request to amend the minutes.
Oh, these are the minutes. I'm sorry, I
Yeah,
lost track of
sorry.
things. Okay. Yeah, typically the minutes reflect motions made, votes taken. We can put that in if it's the committee's desire for us to put that in, but we need a vote to amend it in that way.
So Mr. Peters could amend his motion to adopt the minutes as amended by Mr. Bergdorf?
Yes.
May I see the amendment?
Yeah, can I just see what, just before I sign on to this?
I wasn't trying to...
Thank you, Russ. Are you amending your motion to...
I mean, just since you're mentioning that, do you agree with that, Madam Chair? Since you mentioned it, I just want to make sure.
Yeah, that's accurate.
If the chairwoman finds it accurate, I would move to amend that to include it.
Well, then I will second your amended motion.
All in favor of amending the minutes?
Aye.
Any opposed? Is there a motion to
To-
accept the minutes as amended?
I'll make a motion.
Seconded. Say all in favor?
Aye.
Any opposed? Thank you. It passes unanimously. Minutes are approved. I would like to jump to item 18, if we may. We could take that as order.
Thank you, Madam Chair.
Good evening.
This is Resolution 389. The Albany County Public Defender's Office is seeking legislative approval to request a one-year extension in a council at first appearance grant. It's the second year of a three-year grant. The grant came into effect in 2018. The grant proposal was submitted in February of 2017. It took the state 17 months to respond. And we're requesting, we have $62,475 left to be distributed out of a $250,000 distribution. And we're requesting a one-year, no-cost extension to allow us to do that.
Yes, Mr. Rogers.
Thank you, Chairwoman. Judge, could you just explain quickly, if you could, first appearance grant, nothing in attorney on that?
Part of the Harrell Herring decision that provided legal representation for indigent criminal defendants, that dealt only with 5 counties in New York State. It's since been extended statewide by the statewide expansion. That has aspects of counsel at first appearance in it. But the bulk of the monies to pay for counsel at first appearance, which is the provision of legal representation at every off-hour appearance in court by any defendant or respondent in a criminal matter, regardless of their eligibility for representation. So 24/7, 365, middle of the night, multiple times during an evening or during a week. Our teams of attorneys will appear in court, handle the representation for that appearance, sometimes just that appearance, but very often will continue representation through the duration of any criminal charge. But it provides free legal representation in the county, and this is now statewide. And Albany County has a 3-year grant of $750,000, $250,000 a year, and this is the second year of distribution.
Thank you. Thanks for the explanation.
Mr. Bean?
Make a motion to move it.
Second.
Thank you, Mr. Peter. All in favor?
Aye.
Any opposed?
Thank you. Happy Thanksgiving.
Thank you. Going back to the beginning, items 1 through 11 are tabled. Okay. Which brings us promptly to item 12. Joanne Cunningham's bill regarding plastic straws and cutlery. And we have a handout.
Yep, most of us got it already. Plus one. She didn't, but I saw a couple of them. Oh, she.
Yep, so in your
Yep.
backup, we left in the underlying changes, and then the law without the changes should be in the front.
Yep.
Correct. So as I understand it, the most recent small amendment was to permit drive-through employees from asking if customers could use cups or straws.
Yep.
So, any discussion on,
And the self-service station stuff too, was that?
that was already
That was
part of
already-
it, nothing prohibits the self-service station.
I'd like to make a motion
Thank you, Mr. Peters. What's the motion?
to approve
With recommendation?
with recommendation.
Thank you, Mr. Feeney. There's a motion to move this forward with recommendation. All in favor?
Aye.
Aye. Any opposed?
I'm opposed.
Mr. Kraus, so one opposed. Item 12 passes. Mr. Bullock?
Can I get on this as a co-sponsor, please?
Co-sponsor? Yep.
Thank you.
Mr. Mariello is not here.
Yeah.
Correct? Oh, I'm sorry. Hello, Mr. Mariello.
I'd like to table 13 and 14.
Oh, okay, thank you. Mr. Drake is here. 15.
Yes, I am. Looking to move this forward. I think you all have a copy of local law. This was sent back to law because we had made some amendments. Kind of,
You don't have copies.
One's from last year.
Last year,
Yeah.
You have it, right? We had made some amendments, you can see the changes. It was suggested that we need to have a public hearing, that was done. Unless there are any further questions, we'd like to put this out to vote on the general body.
You want me to talk about it? So, Mr. Drake, and this has been discussed previously, there seems to be an issue here with, you seem to be amending powers of various separate electeds as well as department heads within our charter. My reading of the municipal home rule law is that requires a referendum, which you had in a previous version. It seems problematic to do this without a referendum. Again, you're changing the powers of 14 different sections of the charter. That seems to fall squarely within the municipal home rule law, and so I'll remind the members of that.
Well, again, we had it on there before and everybody suggested that we shouldn't have it on there.
I don't think that's the case.
Okay. Well,
So this requires-
I beg to differ, that is the case. That was exactly the case. It was in there and was specifically indicated they wanted it out. So,
Yeah, I mean, that was-
so there's it seems that the winds have changed in terms of the legal opinion.
My opinions remain constant for the entirety of this law. This requires a charter amendment in my mind.
okay. Well, we already have that marked up, or we already have that version. We could simply, proceed with that. It's already in there. I mean, it's in the original. So, if the committee feels that that's the direction we need to go, then we can certainly go that direction. But it was my understanding that, many members of this body felt that it was not appropriate or not necessary, and therefore that's why it was removed, which is the winds of change that council is referring to. But since we already have it there, we could vote on it with that version in place.
Bill, this is the version that's in place before the legislature. If you'd like to amend it, that would have to happen on the floor. So for tonight's purposes, this is what the committee needs to vote on.
All right.
I have a question.
Yes, Mr. Kraus?
So, are you are you saying that this version could move to the floor, and then amendments would be made by Mr. Drake on the floor to satisfy the concerns that evidently have been raised or counter-raised, or, I'm not quite sure where it all came
Sure.
together there, but do you have objections to the original version that included the referendum?
Right, the objection in that regard would have to do with procedurally how you would go through, the requirements time-wise of when you have to do the referendum. We're coming to the end of the year, so it gets back to, are we going to have the referendum in, presidential primaries coming up this year, so there are some primaries that happen in the beginning of the year. Presumably, you'd have to have the referendum early on to coincide with those primaries. I'd have to look at the calendar as to whether we can get the information in terms of an abstract to the Board of Elections to be certified by the Board of Elections. You need to do that 90 days before the next, whatever the election it is on for. So without looking at a calendar and counting, I'm not so sure I wouldn't have objections to that as well. But to your question, Mr. Kraus, could Mr. Drake propose that in the legislative meeting after it moves out tonight? Certainly, that's his right as a legislator.
Could Mr. Drake also request that what's before us tonight be amended, and the existing or the first version be put in its place instead of this? Could the committee vote on that?
You could attempt to do that. What the committee will do, I can't speak to. But I think for purposes of what we have before us, it makes sense to move out what you have. If that's Mr. Drake's intention, then all the members will understand that. But I think it makes it more complicated to try to amend it here than send an amended version to the legislature. You're better off sending out this version, however it goes out by the committee, and amending it in the full legislature for a vote on that amendment.
I'd be interested to know how to.
Time that he has a...
Yes, so Mr. Drake has a right to get this out. It's a question of how the committee moves it out.
Make a motion to move it out with negative recommendation.
Well, second that.
All right. I will just make a note that I would move it out with a positive recommendation, but obviously I will vote with the committee in order to get it out of this committee.
But before you vote, okay?
But Todd, there's a motion on the floor, so.
Yeah,
You can have.
I can make a motion that today is Wednesday. But the bottom line here is, nobody, it's a circus, I mean, whatever, okay, you don't want me to speak, go ahead, make your motion.
Just let me get it out. There's a motion on the floor to get it out.
And who seconded?
Mr. Touche did, I believe.
I mean, I'm kind of in a quandary because 3/4 of the wording in this was mine. So, I mean, do you want it out negatively?
I'm not allowed to speak
That's
apparently
a motion.
about this, so there's already a motion, I mean, that's not what I want, Dave, what I want was some clarity on this, so,
Yeah.
you
The other option is not as good as...
Well, this motion moves it out of committee.
It'll be out with a
All right.
negative recommendation.
I guess we gotta go for it.
Well, you can vote on it. It's coming out.
All right, all in favor of moving this forward with a negative recommendation?
Again, aye, but please note for the record, it's not negative.
Dave, is that a yes for you? Or?
That's a yes.
Any opposed?
So,
I would have done a neutral recommendation, but that's my yes. I'm still yes.
Okay, so unanimous with
Can we go to 17 before we go to 16?
that. Sure, you can do whatever you want.
Saving the best for last, I'd like to take item 17, if we could, Mr. Touche.
Okay, this is a resolution amending the rules and regulations for Albany County regarding the hiring of relatives. And what this would do is define what a relative is, and it prohibits nepotism by saying no county employee, either individually or as a member of a board, may participate in any decision specifically to appoint, hire, promote, discipline, or discharge a relative for any position at, for, or within the county or county board. And right now, nothing in the county charter or actions of the legislature contain any prohibition on being directly involved in the hiring of a relative. While the ethics law prohibits participating in the award of contracts, grants, or projects, the employment side contains no provision. This legislation is introduced to amend the rules and regulations affecting exempt employees and employers from engaging in the practice. Once it's in the rules, it's in concrete. We'll have a rule which will apply to all hiring officers to keep self-dealing out of the county. With a rule, we're able to make much more efficient, be much more efficient in addressing particular situations. Is taken largely from state law on the subject, but includes very clear definitions of what relatives are to leave out any variance in interpretation. Couple this with a prohibition on financial self-dealing, and the county will be in a much better place.
Make a motion for a positive recommendation.
Second.
Questions or comments?
If you don't mind, go ahead with the question, since it was kind of just quick on the motion.
Yeah,
but-
Sorry about that.
You guys are quick. I understand where you're going with this, and I certainly am opposed to nepotism. I think the definition here is so broad. I think it's too broad myself, and I think it excludes some people who could serve, because this basically says that anyone in this category really can't be trusted, and I just don't think that's a fair.
I'm sorry, say that again?
I think your law basically says that you can't hire a stepson. Is that right?
Yes.
Well, I think that in and of itself, by saying that, just because they have that kind of relationship, it's like, well, we can't do it because they can't be trusted. You know, I find that difficult, because I think it would exclude a lot of top people. And we've had this conversation before. I mean, my God, at the federal level, John F. Kennedy had his brother as the Attorney General. That wouldn't have happened if people had followed this type of rule. And I think that it's extreme. But I think you're well-intentioned here, because obviously there are issues where this is a problem. So based upon that, I will be voting no on this.
All right, there's a motion on the floor. So, and all in favor?
Aye.
Opposed? Sorry, I'm just a little bit hesitant myself, but we're going with the motion, so I'll go with the majority. Thank you. Passes 6-1.
Now, number 16. What law?
Yes.
Yeah.
And back to the main event, number 16. Local law I. Mr. Bullock and Mr. Touche here this evening on this law. Are there any questions or discussions?
Well, I'd just like to point out that there has been a public hearing on this, and the hearing was overwhelmingly in favor of clean air standards for waste burning facilities. In reference to Mr. Bergdorf's amendment, we are waiting for an opinion from the county attorney, which is supposed to be delivered by December 13th. And so we'd like to vote on this on the 16th.
So, Mr. Touche is correct. The timeframe in terms of having the county attorney look at this and give an opinion, he respectfully requested that the committee give him a little more time till the 13th to deliver that opinion, which he has promised will occur. Because our schedule is a little cramped this time of year, we don't have time to have another committee cycle. So the suggestion would be to move it out tonight, however the committee sees fit, and to not have a vote on this on the 2nd. This will not be voted on December 2nd. This will be voted on pending the county attorney's opinion and whatever comes along with that. I can't predict what will be in that opinion, but I think it's wise to at the very least wait till we have a county attorney's opinion on this before any actual vote on for tonight. Again, I'll leave it to the committee to move it out, however you see fit.
No action will be taken on it for December.
With the understanding that no action will be taken on it until December 16th,
So
at the earliest.
I'd do a positive motion for it to go out with a positive recommendation with that understanding.
A question. Who will make that determination
Who will make,
when it's actually considered? This committee is saying, we want to move forward with the understanding
Sure.
that it won't be considered till December 16th.
Right.
But who will make the final decision as to when it is considered?
so it's a leadership decision, but assuming that everything stays in the status quo now, it won't be placed on an agenda until the 16th. And that seems to be the position of leadership at this point.
Just on behalf of Mr. Bergdorf, and I actually went back and reviewed the tape from the last meeting. There was a lot of discussion at the last meeting about the substance associated with the legislation, and at that point, it was indicated, well, the discussion for substance could occur after the public hearing. So in fact, there's no discussion about the substance occurring this evening. There's no county attorney opinion available to review, to discuss, and also there was pointed out last meeting that there's no fiscal analysis. To my understanding, we don't have the expertise in the county to actually do this type of review and inspection, nor does anybody really know the costs associated with this. So that may have a very negative impact upon the budget. And then there was also a point brought up that the comptroller's office is doing a solid waste plan right now, I'm not sure exactly which office, the county executives, I think, is doing it. But in any event, there's a review of overall waste for the county, waste disposal facilities and an overall plan that this may or may not play into. And also, it's my understanding there's new material that's been coming in from experts that are associated with business in this particular area. All that being said, it would seem that it might be a little bit premature to move this forward without an adequate vetting, especially from a fiscal analysis. I know all of you are very concerned about the budget. This could have a very, very negative impact on the budget. I don't think anybody disagrees, especially Mr. Bergdorf, that we want clean air. But at the same time, this is a significant piece of legislation that's literally received about 15 minutes of discussion at the last meeting, and that was put off because because the public hearing was coming up. So.
This is a significant piece of legislation, but it's not a significant budget buster. The cost of this is negligible. The county has employees that can do the research and the gathering of the data. And, I don't see any cost to the county whatsoever besides a possible lawsuit. But the lawsuit, I think, would have come when the Queens Law was passed, and it hasn't come yet. So, I don't see any problem with this local law being voted out of this committee, especially after the hearing, and especially after we vetted this publicly, which I was at. The speakers were 30 to 1 for this local law. So, I think everybody is aware of the requirements of this local law. I see no expense to the county on it, and I'd like this committee to move favorably.
Mr. Mariano?
Madam Chair, I'm not a member of the committee, but am I allowed to comment, ask questions? During the public hearing, obviously, we're not allowed to ask questions of the speakers, but there was one speaker that spoke that really caught my attention. and he spoke about the enforcement of this. How would, and you're talking about it not really costing the county much. Well, how do we enforce this? Would we have to hire an individual? What qualifications does that individual need to have? What training will that individual need to have? What equipment will we have to purchase for that person to do the inspection? So I would agree with Counselor here that we're rushing into this, and I mean, if we have a well-written, tight law, I think everybody would vote for this because we're all in favor of clean air. But it seems like there are a number of questions that still haven't been answered, and I think we probably should consider this a little bit longer and make sure we button this up properly.
Mr. Touche, did you want to speak to the enforcement provision maybe with Mr. Ewell while he's here?
Well, yeah, I think, could we ask Mr. Ewell to speak?
Okay.
Yes, please.
Might want to speak as well.
Yeah.
I think you should.
Yeah.
There's also a motion on the
You got a motion.
Right, and that's fine.
That's Mr. Counselor.
We often engage in situations where we will delay a final act of a committee until the post-public hearing or post-public comment after we've had an opportunity to gather some additional information. And in this particular case, if we're considering the bill at the December 16th meeting, by that time we will have the letter from the county attorney and perhaps some additional information. Why wouldn't we just wait until that time to actually take action on the bill? It would still be eligible to be voted upon on December 16th, but we would have the benefit of some additional information and not have to move this thing out tonight.
You could do a postponed form. That's correct, you could do it that way.
I mean, I think at least that way, we have something in hand, there might be some additional information that we could utilize, and, you know, the committee would still have the final say as to whether it would be moved out, and it could be handled at that meeting.
No, well, you'd have to table it here. If you're going to go that route, you'd have to table it here and then call for, the chair would have to call for a post-public forum.
I made a motion, yeah.
That's correct.
Right.
Just wondering, I was just looking at the calendar, and the 13th is a Friday, so that's when we get. But I don't know if anybody in the legislature has the technical expertise to actually vote on this, honestly. I was just wondering possibly, and I know it's Christmas time, and we get the 14th and the 15th would be a weekend, but maybe even before the 13th, we could get opposing sides, maybe just come in and speak to us something.
But wasn't
I'm
that-
not comfortable with this, I'll be honest with you. I'm just not. I don't know, I don't have enough knowledge.
Wasn't that what the open, I mean, are we want to do a second, like,
Yeah.
public, I mean,
No, I mean more from Lafarge and from the citizens groups or whoever.
Just as a procedural note, if the committee is inclined or the legislature is inclined to go that route, we're going to have to schedule meetings to comply with open meetings law. So I want to make sure that we can't have meetings, bringing in separate interest groups as a legislature without properly noticing it for open meetings law purposes.
If we're putting
So,
the thing off to the 16th,
Yep.
we could have, that gives us plenty of time for everybody to chime in from, you know, competing different points of view.
right.
And,
Sure.
you know, so I would say that people, if they want to get us information, start getting us the information sooner than later,
We're already getting it.
you know? And then that gives us more time to chew on it, so to speak, and, you know, learn a little bit more about opposing views. So I don't have a problem with maybe.
you'd have to
we
table it tonight.
And we could have a post-public
Forum meeting on the
law committee
16th.
meeting on the 16th.
Right, which would have to be requested by the chair.
And that gives us several weeks
That would-
Gives it-
for everybody to give us all the information they want.
That would be my recommendation.
And
I
you're-
would-
How do you like
I
that,
would-
Frank?
I would ask,
And to be honest with you, what I'm thinking here is, what's the rush? Why can't we just vote on this in January? I mean, why don't we just make sure we have all our ducks in a row and get all the information? And
So,
does it matter if we vote on it a month later?
Start the whole process.
right, so to that question, Mr. Moriello, the procedure of this legislature is everything that's currently on the agendas would, by operation of our procedures, drop off. So if you were inclined to go that route, another member would have to reintroduce it, and it would restart our entire legislative process.
So then we would vote on it in February,
April.
March.
March or April.
I mean, even if, I'd rather have something that's buttoned up and a good piece of legislation than just rush through something now just to get it passed.
Don't know if it's gonna pass, right?
No, we don't.
Because it's going up for a vote, doesn't mean it's gonna pass.
So you're proposing a
So
meeting
you'd be
between
proposing
now
to-
and the 13th?
You'd be proposing to table it now.
Table it now.
You'd need a motion to table, a vote on that, and it sounds like the committee is inclined to call for a post-public forum on the 16th, which will happen operationally, through our processes, but right now it would be a motion to
So
table.
we'd have to,
That's right, in the morning, or excuse me, it's at 5, right.
10:30, I think.
We'd have to, yeah, so Mr. Peters just pointed out, a good point. The post-public forum would be a little later than normal because we have some other matters to deal with on the front end. We could still hold it, but it would just be a little later than normal.
I'd rather move this without recommendations, pending meeting with constituents and pending the county attorney's opinion.
so do we need to have Mr. Peters remove his motion, or?
Well, he's
was
nobody
the
seconded.
No, and no one was
You can
seconded, so
withdraw it if you
I'll withdraw it.
All right, so then I would make a motion, unless you wanted to.
I'll make a motion to table.
Okay, motion to table, is a second? Okay.
With the understanding that, we.
And request the chair to call a post-public forum.
We weren't gonna vote on it for the 16th.
And we're absolutely sure that we're meeting all our requirements and things like that, so there's no excuses not to meet on the 16th. Just confirming that,
As
that's,
long as the chair calls it.
Yeah.
okay.
We can move it out at the post-public forum.
Correct. In that, if that's the scenario, then you would have a post-public forum, law committee meeting the night of the 16th. My office would already have it on the agenda, so it would be there contingent upon successful approval out of the law committee.
Okay.
We could find at that meeting, if some of the concerns that were expressed by Mr. Morello and council, we found that there was a reason to postpone, the committee could then take that action.
Sure. I mean, the committee has the ability to take whatever action it deems necessary, given the county attorney opinion and other surrounding circumstances.
But would we be able to table it again?
If you tabled it in that meeting, it would fall off,
Right.
Start all
right,
over.
because December
All
16th.
right. But would we have the right to do it if we wanted to?
Sure you would.
Okay, all right. That wouldn't be up against the
Right.
time frame that it needs, that they could require.
Right.
Okay. All right.
Since we have an even number, what happens if we tie?
If you tie tonight, and we've been through this a few times, a tie in a parliamentary context is analogous to a non-action, so it would stay in committee, and you'd be in a similar situation where you'd have to, if you wanted to act on it before the 16th, call a post-public forum to consider it again.
So we have a motion and a second.
So you have a motion and a
Motion
second to table
on-
it.
On tabling, all in favor? Opposed?
So I just need to count the votes here. So is it 3-3? So it's tied, so for the purposes of this, it stays on the agenda.
Unless I can make a motion to move
Sure.
it without recommendation.
You could do that. If you want to make that motion, you need a second.
Second.
Thank you. It's going to end up at stalemate again, but
All right, all those in
all in
favor?
favor?
Aye.
3, and opposed?
Are you 3 opposed to moving it out?
Without recommendation, and this is with the understanding that we'll be having the county attorney's opinion and an additional
So, and we
meeting.
wouldn't take any action on it until the 16th?
Correct.
Correct.
And we'd have a post-public forum meeting on the 16th.
I'm sorry, I'm getting a little confused at what that vote was for. So
Sorry.
that was a motion to move it out without
Without
recommendation. We have
recommendation.
3 yes to move it out without recommendation, and we need the 3 on this side's vote.
I don't know.
And this is moving it out, so we're not gonna have a post-public forum.
Yeah, this would be
Correct,
to
you're right.
move it out,
Right.
this committee.
Okay.
But we wouldn't take it
With the
out.
understanding that
Right.
it
We
won't be
wouldn't take
taken
it out
up
till the
until the
16th.
16th.
Correct.
Yes.
But just procedurally,
Yep.
didn't we just have a vote before that?
Yeah.
That was a no vote, because
Yep.
no action.
Yep.
So that should end it? Why
So-
shouldn't we be able to bring it up again?
The interesting, yeah, this is an interesting unique thing of our legislature. We don't have yes or no votes. Our organization is not set up that way. We have a tiered system of voting, and procedurally, we are allowed historically to go through the tier if one fails. So the tie was essentially a failed vote. Our practice is to go through the tier. Unlike other legislators, most legislators don't have a tiered system of voting. We're unique in that context. And that's why we're allowed to have a vote going forward as we have in the past on this. So I just need to get the vote here. We have 3 yeses to move it out without recommendation. Mr. Kraus is a no. Mr. Mayo and Mr. Yes. Okay, so it moves out without recommendation.
But with the understanding that it's.
With the understanding that it won't be
Right.
voted on until the 16th.
Right.
I'm just, I'm curious as to why we didn't go the other, it's the
As it
same
lost,
thing.
it lost. It's 3 and 3. It's 3 and 3.
Which means it would stay stable, and then it would be considered a post-public hearing.
The difference is now you don't have to have a post-public forum meeting law. That's the difference. That's substantively the difference
But I
here.
thought that was the whole point, so that we would be able to review it again.
I can't speak
Without
to
the-
the intentions of this legislative body. I'm only here to advise from a parliamentary context.
You have my no vote on that.
Okay?
The motion to adjourn?
Second.
Thank you, everybody.
Thank you, Madam Chair.